everyone. Thanks so much to the ChIPs folks, Joan, Bridget, Jen, Mo, everyone for putting this together for us. And welcome to everyone to today's webinar, where we are going to be talking about IP deal breakers in M&A transactions. Before we get to our presentation, I wanted to introduce myself and my colleagues from Ropes & Gray. So I am Emily Carlberg. I'm a counsel in our strategic transactions and intellectual property transactions group. I sit in our San Francisco office, and I'm joined by Erica Hahn in Boston and Georgina Suzuki in Silicon Valley. I'm going to let Erica and Georgina give their own backgrounds, but my practice focuses particularly on complex intellectual property matters that arise in the context of strategic M&A, asset divestitures and integrations, corporate partnering, strategic alliances, and the licensing and commercialization of IP. I began my career almost a decade ago as a corporate attorney and quickly developed an interest in technology and IP. And over my years, I've advised numerous venture-backed companies in sales, complex corporate partnering deals, joint ventures, licensing agreements, and the bulk of my practice is on buying and selling technology companies. At Ropes, I primarily advise strategic acquirers and financial sponsors on IP matters, and I have a particular interest in post-closing technology integrations and licenses. I've worked on both the East and West Coasts, and my practice has spanned a broad array of industries from, fintech to semiconductor to ed tech. So this program is really right up my alley. So let me kick it over to Erica Hahn in Boston to introduce herself.
Sure. So I'm Erica Hahn. I am a partner also in the strategic transactions intellectual property group with Emily. I'm on the East Coast counterpart to Emily. My practice focuses on consumer branded product companies, but I also work with a number of industries, including healthcare and technology companies as well. The types of transactions that I work on include typical M&A transactions, complex carve-out transactions, licensing collaborations, whole business securitizations, and any number of supply chain or IP related questions that arise from our clients. So very excited to be talking about some of the real life pitfalls that we've seen in our practice here today. Thanks for joining.
Georgina, could you give your introduction?
Yes. Hi, everyone. My name is Georgina Jones-Suzuki. I'm an IP strategic transactions attorney in our Silicon Valley office in Palo Alto. My practice is both focused on life sciences and technology companies. I advise companies on licensing and collaboration deals, complex IP carve-out issues, commercial agreements, digital health issues, especially where data and AI are involved. And I look forward to doing this presentation with all of you.
All right. So before we get into it, a little more about Ropes & Gray. Our firm is headquartered in Boston with offices around the US, Europe, and Asia. We have a really strong intellectual property practice, both on the litigation and transactional side, and have been recognized as a top firm for licensing and collaboration matters, as well as patent and intellectual property matters. Some of the recent awards Ropes has won is up on this slide here, so I won't read them for you. But one point not included on the slide that I wanted to bring to the ChIPs community is that Ropes is a firm really committed to women and diversity in our workplace. We've been recognized as a top firm for women attorneys and have one of the highest percentages of women in equity partnerships. So as we get going, just a quick note that we've reserved time for questions at the end. So please do feel free to put questions in the chat, but we have a ton of content to get through. So we're hoping to run through as much as possible and then try to get answers to all of your questions at the end. So with that, I will pass it over to Georgina to get us going.
Great. Let's go to the next slide, Emily. So the common theme of our presentation today is going to be how to transform your business to deal with IP risks. And we're going to go through 5 case studies, which we hope illustrate some of the most important and complex IP issues that we typically encounter. But it's not enough just to say, is this a problem or is it not? The harder question is, what do you do about it? And we are presenting on the basis that, or on the assumption that most people have like a 101 understanding of how to do basic IP diligence. And to do a brief recap of that, there's usually the asset side of the balance sheet and the liability side of the balance sheet. On the asset side, you ask yourself, well, does the IP look, okay? Is it registered? Are there chain of title issues? And on the liability side, you ask yourself, well, is there some significant litigation that's going to cause us to incur significant costs, such as, a settlement amount? And so most people, particularly attorneys and business professionals, can identify, yes, there's a problem, or no, there's not. But the question is, what do you do about it? And it's really important for businesses to think about how to transform their policies, their procedures, how deals are structured in order to effectively deal with these risks. And we think this is going to be of particular importance, in the coming year and beyond. We've certainly seen slower deal activity over the past year, but it's certainly been ticking up just in the past month. We think technology and software are going to be hot items, in the years to come. We think there's going to be more of distressed sales. While certain businesses might not be doing well, there might be distressed asset situations where M&A and divestiture issues are going to pop up. So we think this is something where businesses need to be thinking about, how do I prepare for potential acquisitions, and what do I need to do to transform my business to adjust to those risks? So next slide. You can go to the next one. So the first case study involves licensing poison pills. And here's the hypothetical, and we'll just walk through it. Bright-eyed Biotech grants an exclusive license to Giant Pharmaco so that Giant Pharmaco can research, develop, commercialize, manufacture, or otherwise exploit all compounds and products directed to cancer target. Now, the IP that's licensed includes both patents and know-how controlled by Bright-eyed Biotech. Now, here's a key word. It's controlled by Bright-eyed Biotech and its affiliates. And the IP is necessary or reasonably useful to exercise the license. Now, Bright-eyed Biotech is really interested in getting acquired in the future by even bigger Pharmaco. But what snafu did Bright-eyed Biotech commit here? So moving on to the next slide. Without any additional context here, the word affiliates is a really loaded term in a contract. If biotech wants to get acquired and it says affiliates, it's possible affiliates will pull in the acquirer and the acquirer's affiliates. And if there's an exclusive license grant, it's possible that the acquirer's IP will get tangled up in it. It might not have consented to that. In fact, that IP might already be encumbered. And this is the type of thing that can be a poison pill in a deal. In fact, improper use of the term affiliates is the type of issue that gets people fired on deals. So we think this is a pretty important one to talk about in this presentation. So this is really important in the context of licensing, covenants not to sue, as well as settlement agreements. We see it all the time in the life sciences space with licensing and collaboration. It's also really important in, say, like defensive use situations where, like, say, chip and semiconductor companies have entered into a collective agreement in order to license each other, and then one party leaves the arrangement. These types of issues pop up in those types of divestiture situations. So when you review a contract, or when you're thinking about drafting a contract, think about the word affiliates. And you always want to think, is this appropriate in the particular context? And you need to think about acquirers that acquire you, but also entities that get divested. You need to think about each one of those two situations. And so we're going to run through some tips that you look through in contracts and things that you should make sure are addressed. The first one that we see all the time in diligence is that one party is contracting to the agreement, but instead of saying contracting party only, it says contracting party and its affiliates. Therefore, all of the affiliates of the company are signatories to the agreement. As a best practice, we recommend that only one entity sign an agreement. Part of the reason for this is that the entity might not be in a position to bind its affiliates to the agreement. They're separate entities. And in fact, the other affiliates might not even be on notice that they are parties to the agreement. And suddenly they can find themselves liable to the counterparty. So as a best practice, keep it limited to one, or if you have a principled reason for including others, then you can include it. Additionally, affiliates should only be affiliates so long as control exists. The definition of affiliate makes reference to controls, under control by, or under common control with. And if you're no longer, within that control framework, you're no longer affiliate. So we typically recommend that there be language like, so long as such control exists, because if you're no longer affiliate, then you should no longer be subject to the terms. It's also really important to carve out the IP of acquiring entities and their affiliates immediately prior to the acquisition. There's various language that you can include on this point, and we definitely recommend including it in control definitions for IP or in the definitions of affiliate as appropriate. It's also important to think about financial buyers, like private equity firms and their portfolio companies. Broad use of the term affiliate can pull in those types of entities, and they should not be subject to the agreement. So typically what I do in those contexts is I say highest level, highest entity in the organization and its subsidiaries. And then it doesn't pick up the private equity firm above that or necessarily its portfolio companies. And lastly, think about the divested units. You typically don't want the divested unit to be the divested unit and all of its affiliates, because maybe all of those affiliates will include potential competitors. Instead, limit it to just the divested unit as its business exists at the time of divestiture. You don't want to pull anything else beyond that. So those are some best practices, but we also want to touch upon, an innovative thing that we're saying. It's not done all the time. It is pretty rare, but it is really interesting. And it goes back to the transformation issue. There's something that we call a patent library check-in, check-out system. And the way this works is, imagine you have company A and company B. Maybe they were once affiliated with one another, but through a divestiture, they're now two separate entities. And there might have been a lot of debate, during the divestiture about who's going to own what patent and what patent's going to be licensed to the other. And maybe company B that's being divested doesn't have a lot of comfort that it's getting all the patent it needs, once it exits the relationship. Well, one creative way for dealing with this is to have patent A retain, or company A retain the patents. And if company B gets sued, company A assigns the patents to company B. And therefore, company B relies on the patents in connection with the suit. It checks out the patent from the library. And then once the suit is over, it checks the patent in back to the library and assigns the patent back to company A. So there's certainly complex things that organizations can think about as they go through complex divestitures with numerous affiliates issues. So that's our first hypothetical, and I'll turn it over to Erica for our next one.
So this case study, we just talked about patents. This case study is focused on trademarks, and this actually is taken from a number of real life deals that we have done, sort of a mixture of them, and issues that have come up in transactions that we've worked on over the past year. And this is a fairly common issue. And I will say that the question of who owns the trademark in a situation where there is a spun out company that is going to have the same brand can be the gating item in a negotiation. And so one of the mistakes that we have seen is the parties saying, well, we'll do the trademark license last, because in our experience in a situation like this, this can actually be the most controversial part of the negotiation and should be started and thought about as soon as possible. So I'll walk you through this scenario. So let's say there's a company, Chocolate Chip Cookie Inc., which makes chocolate chip cookies and a number of complementary products. And it's decided it wants to, needs some liquidity, needs to focus, sort of streamline its business. And so it's going to focus on just the classic cookie business and it wants to spin out the complementary products business and find a buyer for that part of the business. Let's say the complementary products are, things like cookie dough, ice cream, protein bars, and they're going to continue making the cookies. And the idea is that the company the seller will retain the chocolate chip cookie brand and business, and there will be a chocolate chip cookie enterprises business that is spun out to do these other things. And so there's a buyer that comes in who's interested in buying the chocolate chip cookie enterprises part of the business. And the question is, where does the chocolate chip cookie trademark go? So before we even get to that question, the question should be asked, is it necessary for both the seller and the buyer, so both separate businesses after this transaction, to both use the chocolate chip cookie brand? And I will say as an aside, chocolate chip cookie obviously is a generic term, could never actually be used as a trademark, but this is a placeholder. Imagine something really creative and coined and ownable is the brand that we're talking about here. So in this scenario, it's definitely less complicated and easier if the seller or the buyer or both just changes their brand, right? And so then they're not tied to each other. There's no licensing to deal with, and they can go their separate ways. However, a lot of times in these transactions, the value and the interest of the buyer in the spun out business and the value to the seller in the retained business is that brand that often has for years built up goodwill and a reputation. And so very often, especially when we're representing buyers in this context, the buyer will say, this is all the value. We have to keep the chocolate chip cookie enterprises name because that's why consumers are buying this cookie dough and this protein bar. We're not interested in it. So assuming that's the case, then the question is, how do you deal with trademark ownership? And a lot of times the business principles will say, the new business will own chocolate chip cookie enterprises and the seller will own chocolate chip cookie, and that's great. And the problem is that legally that is not actually possible or recommended for a number of reasons. So you sort of have the practical reason is that if you're planning to register these trademarks, it is not possible to have two completely separate entities own identical or near identical trademarks for identical or closely related goods and services. You could have a coexistence agreement that says you'll explain how you will avoid confusion, but trademark offices are not, in many countries, are not bound by the terms of those coexistence agreements. So even if the parties think that it's fine to have two separate owners, you may still practically not be able to have two different entities register those very closely related trademarks. So that's one technical problem. Additionally, it's not a great idea for either party that there are two separate owners of very similar trademarks in a similar space, because then you're diluting the strength of that trademark, right? So if it were the case that you were able to figure out a way for chocolate chip cookie enterprises to be registered by one entity and chocolate chip cookie to be registered by the other, what that does is it potentially opens the door for third parties to come in and say, well, I'm chocolate chip cookie, headquarters, and there's room for us too, because you've already sort of diluted and created a crowded field. So it's not great for the brand as a whole. It's not great for either party. And therefore the question is, what do you do instead? And so this is on this slide is the menu of options. There's no perfect answer, especially an answer that will make all parties happy. There are pros and cons to each. And so this is really important to talk about early in the transaction, so everybody is on the same page about what is actually being negotiated and what documentation is required. So the first option is that the seller, the owner of the chocolate chip cookie business, retains the trademark and grants a license to the buyer to use chocolate chip cookie enterprises for its products. Conversely, the buyer could buy the trademark and assign it back to the seller. The third option is that the parties could each create a joint venture IP holds company and jointly govern that trademark and license it out to each of them separately. And finally, as I mentioned, you could think about a situation where there are enough differences, particularly if the parties are geographically completely separate. Although then you get into issues of who owns the internet and how do you sort of geocamming your sales that are online. But assuming you are completely geographically distinct, then it might be possible to have the parties own their respective trademarks. But in that case, you would want a coexistence agreement kind of governing what both parties are going to do with the brand. So those are all of the options. I'll walk through some of the pros and cons about the different options. So if you can keep on the past slide for just a minute. So the license options, whether it's the buyer or the seller that is the owner and licensing it to the other. The problem there is that whichever party is the licensee has to rely not on the rights of a trademark owner in terms of enforcing your trademark or registering your trademark. You have to rely on contractual obligations of another party to do the things that you need to be done. So it is possible to write a great license that's very licensee favorable and gives you a lot of great protections and control. But in the end, you are relying on another party to do something at all times. And so if the relationship is great, it's usually never a problem. If the relationship is antagonistic, then you're potentially constantly fighting over, you're obligated under this contract to register this new trademark for me. You have to do this, right? And you can do things like get powers of attorney so you can avoid those conversations. But as the licensee, you don't have direct control like you do as an owner. On the other side, being an owner, when you have a licensee that has pretty big rights, can be an administrative burden, right? If you are the party who is the owner and is licensing it to the buyer, let's say, for example, and you have obligations to register the trademark or to cooperate on enforcement, those are additional burdens unrelated to your business. And certainly they may be paid for by the licensee, but somebody has to deal with those. So it's not ideal from either situation, but it's definitely possible to draft language that kind of eases those administrative burdens and sets expectations. The joint venture is definitely preferred from a control standpoint, since there's equal control of that trademark, but it is very expensive and very complicated. Just setting up the structure of the joint venture and the requirements is a pretty big endeavor. And if the trademark is that valuable, it can be worth doing. But it takes, there's governance, there's meetings. If you want to bring a lawsuit, there's kind of layers of explanation that you have to do to sort of explain how that's working. And so that can be its own complication. And then, as I mentioned on this coexistence agreement point, you could consider a scenario where the trademarks that were being used by the different entities were different enough that it might be possible to get comfortable with two different owners. One example might be, let's say the seller keeps the trademark chocolate chip cookie used in connection with actual cookies. And let's say the buyer is going to use the acronym. Instead of Chocolate Chip Cookie Enterprises, their entire trademark and brand is going to be CCCE, right? They'll say, we'll never use it spelled out. We're going to be CCCE. That's going to be different because over time, consumers will think of those as two different things. We'll use that in connection with sort of the complementary products. Even if that happens, it's usually a good idea to enter into a coexistence agreement outlining what are the guardrails of both sides and how are you going to avoid confusion. The hard thing is that if there is another, under any of these scenarios, if there is another company out there that you don't control that has the same brand, you can have the best contract in the world, but if that other party does something that's very bad and is reputationally damaging, let's say the chocolate chip cookie company poisons a bunch of people who ate their cookies. If you share a brand with that company, regardless of the fact that you had nothing to do with that poisoning, consumers may sort of think about that reputation and it could affect your brand too. Regardless of whether you have a contract that says you get damages, if that happens, sometimes those kinds of issues are irreparable. So that's something to keep in mind if the parties are agreeing they're going to live in this world when both have very similar trademarks. Okay, Emily, you can go to the next slide. So once you figure out what the structure is, then you want to think about the details that go into whether it's the license agreement or the coexistence agreement or the joint venture documents. It's important to think up front about how these things will actually work in practice. Definitely, as I mentioned, not a good idea to save this agreement until the end or post-closing, because a lot of the details actually really matter to the business people. So the first thing, as I mentioned, is ownership. Obviously, you have to figure out who's going to be the owner. Quality control, as most of you probably know, is a requirement, at least in the US, that the trademark owner has to exercise quality control over the licensee. And sometimes the way that this gets negotiated is through how that will work, right? You can have quality control language in the license, but does everything need to be approved? Do you pre-approve everything that's in existence as of the closing? And send samples occasionally. Those details actually matter just from a business operational standpoint, and it's good to figure out up front. Similarly, prosecution control. Who is going to be making the decisions about whether and where to file trademark applications? Who's going to pay for those? Those can be pretty complicated. Sometimes you might have trademark registrations that are relevant to both parties and share the costs, and sometimes it's clearly one or the other. But again, the trademark owner is, all of the filings have to be made in the trademark owner's name. So there has to be some cooperation there. On the enforcement side, there's also a question of who gets to sue third parties for infringing those trademarks. And in these situations, a lot of times, each party will have the first right to enforce the trademarks in its field. So if it's related to cookies or specific geographies, however the business is divided, the one party will have that first right, and then the other party will have a second right if the first party decides not to take action. So that can get, again, it's all about the details, and you want to think through, especially if your client or your company is the licensee in this situation. How do you get as close to being an owner as you can? How do you make sure that you can still stop infringers or counterfeit goods and all of the things that you would normally do as a brand owner? Another thing that comes up a lot in these agreements is modifications to the brand over time. Right? Maybe you want to make a variation. Maybe you want to have, add some wording or add a new logo to that chocolate chip cookie trademark. And ideally, you want an agreement that allows the flexibility to do that. And is not sort of set as to the brand as it exists on closing, especially if the license is perpetual. That's a long time and brands change. Exclusivity is another big question that comes up in these agreements. And often there will be two types of exclusivity. So in the example we said where the complementary products business is going to be called Chocolate Chip Cookie Enterprises, you can imagine part of that license, if it was taking a license, would be Chocolate Chip Cookie Enterprises, full stop. That trademark can only be used by the licensee. So the seller, the business that has the cookie business, can never use Chocolate Chip Cookie Enterprises. That's solely for the licensee. But then you might also think about field exclusivity. So you might also, as a buyer of that carved out business, ask for a covenant that says, but you also can't use chocolate chip cookie in connection with bars and cookie dough and ice cream and whatever those boundaries are. And that part, the boundaries of that field exclusivity, can get very heated in negotiations, right? Because the parties are potentially binding their businesses for a long time. And this exclusivity section of a trademark license can be a way to effectively get more out of a non-compete. So you might think about a situation where the seller of the business agrees, I'm not going to go into ice cream for 5 years. But if you have a perpetual license that gives exclusivity to the chocolate chip cookie brand and all variations in ice cream, potentially forever, then after that 5 years is up, the seller could theoretically start doing ice cream, but they wouldn't be able to call it chocolate chip cookie. And that's a big advantage to that buyer. So this is a way that you can kind of extend some of the benefits of a non-compete. And that's also why it's a pretty heavily negotiated issue. In terms of term, a lot of these agreements are perpetual with limited termination rights. Sometimes, however, you'll have a transition period. So you might say, okay, you can be Chocolate Chip Cookie Enterprises for 2 years, but then you've got to find a new brand and we'll give you a transitional license. The termination provisions are also heavily negotiated. As a licensee, you want an irrevocable license that can't be terminated. You want the licensor to only be able to sue you or get an injunction if you breach. And of course, as the brand owner, you want some some threat of termination to actually get the licensee to comply with its agreements. And that's usually pretty tricky. Beneficial ownership is a question that comes up for tax and accounting planning. So it is possible to not be the legal title owner of a trademark, but as a licensee to have so much control and so much economic benefit of that asset that it can be considered an asset in terms of beneficial ownership from a tax and accounting standpoint on the company's balance sheet. And if that is really important, then there are certain pieces of that license agreement that the tax and accounting teams will be really focused on to be able to make that beneficial ownership determination. And similarly, assignment costs. So if the trademark is actually going to be moved to a new owner, keep in mind that you have to record that ownership in all relevant jurisdictions. So that can add cost to the transaction. And then a tax advisor should think about the consequences of where that IP is going and where it's landing and how it's being licensed. And then the final point to think about is US intent to use trademark applications. I'm sure as many of you know, cannot be assigned except to the successor to a business if that business is ongoing and existing. In our hypothetical, you probably could assign intent to use trademark applications because the exception would apply. But sometimes if there is an internal restructuring prior to selling the business, that may not count. In which case you may have to hold back the assignment of those intent to use trademark applications until you file a statement of use or evidence of use. And that's a lot of detail for another day because we could talk a lot on that topic. But I think the point of this is ownership of trademarks, especially if the brand is an important driver to the value of a transaction, should be discussed early, and the details should be discussed early, because if the parties sort of wait until the end, a lot of times they haven't really thought through all of these things that they might have to live with forever. So those are things to keep in mind and add value as an IP lawyer and raising them early. And I think that's everything. So I'll turn it back over to you, Emily.
Thanks, Erica. I'm going to move on to a slightly different topic, which is related to the offshoring of IP and your IP development. This case study is based on a real deal, well, several real deal scenarios that we're seeing with more frequency as US companies are considering and thinking through the benefits of offshoring their IP development, which basically just means that they are sending IP development out to foreign countries. Basically, Taco has decided to offshore its software development to an Indian subsidiary where it will hire its own employees, it will train them, it will pay them a fraction of the cost to develop and improve the company's proprietary software. All is great. The Indian employees sign very short employment letters that tell them just what they need to know, their job title, their salary, and their start date. Taco will also be retaining a contractor in Brazil called Burrito Co. to develop its new mobile app. And then business is going so great, customer sales are through the roof, that Taco is approached by Mexico, who is interested in an acquisition. But Mexico is a sophisticated buyer, and they think that Taco is the real deal, but they want to do a full diligence of the IP to ensure that they're properly valuing the software assets that they'll be acquiring. Any issues here? So you do have a ton of great advantages when you're offshoring your IP development, particularly with respect to the reduced costs. You can minimize overhead and expenses. There are some tax benefits to consider, but there are also serious risks that buyers are keenly aware of and will want to take into consideration. The first key takeaway is a pretty routine diligence exercise that would bring up IP issues. So one notable problem in our Taco Hypo was that you have an Indian subsidiary with Indian employees developing software for the Indian entity, but there is a missing transfer between the Indian entity and Taco itself. So the IP technically is going to be sitting at the Indian subsidiary level with no transfer of ownership over to the US entity. And the US entity is providing the services and the software to its customers. So To ensure you have the proper IP ownership and chain of title, one solution here is to put in place an intercompany services agreement to effectuate the transfer of IP and to permit TACO to validly use and license the IP. But where you are doing this, you have to be a little careful to consult with your tax and regulatory experts. There are transfer pricing and export control rules that a company will need to comply with, and a buyer will want to ensure that the target isn't going to be subject to regulatory sanctions or other significant consequences in the event they are failing to comply with export control and tax regimes in foreign jurisdictions. Along those lines, it's also critical to ensure that any offshoring activities are in compliance with local laws where they are taking place. So for example, TACO might have thought that having short and limited employment agreements without sufficient US IP assignment language would be fine, because in the US, we have this concept of work for hire, right? Where copyrightable works created by employees within the scope of their employment are generally owned by their employer. But this is not always the case in foreign jurisdictions. Some jurisdictions don't have work for hire doctrines, and other ownership laws have significant nuances that raise IP ownership issues with employees developing key IP. So anytime we have a company engaging in offshore IP development activities, we always advise that they consult with local counsel to ensure that IP assignments are properly in place, employment agreements are properly in place, compliance with tax laws, and any other issues that might come up in the foreign jurisdiction. The final major concern for acquirers and targets engaging in offshoring activities is how they're going to be able to protect their trade secrets and prevent the risk of IP theft. There have been a number of cases recently where a US company is offshoring its development and product designs to foreign contractors, and then the foreign contractor turns around and steals their trade secrets and develops a product to sell in that market. So there's always this heightened risk that offshore contractors and employees who access trade secrets and sensitive confidential data could be using that in ways that are not intended. And the real problem that many US companies face is how to figure out what recourse they would have if they have this problem. Some jurisdictions don't even have local laws that would cover the theft of trade secrets. So one way to get around that is to ensure that you have full degree of control over IP development in foreign countries and are consistently monitoring to manage the risk to ensure that your trade secrets are being protected. With that, I'm going to turn it back to Georgina.
Great. So this is a hypothetical dealing with data. And by data, I mean data as an IP asset as opposed to privacy regulations. So during the COVID pandemic, foot traffic plummeted in Cookie Inc.'s brick and mortar stores. And as a result, sales are down for Cookie Inc., but it has seen some positive sales growth for its online cookie store. Now, Cookie Inc. wishes to spin out its brick and mortar cookie business and sell it to a third party, but it wants to retain ownership of the online cookie business because it was so profitable. However, both of these businesses retain or want to use valuable customer data used in both businesses, particularly with respect to their glutinous cookie loyalty program. Now, to keep this simple, we're going to assume that each party only operates in the United States, don't have to deal with the GDPR, the elephant in the room. But what are the major issues in this deal? So moving to the next slide. There might be privacy notices or policies that do not actually allow you to transfer personal data, including within the context of an acquisition. And it can be quite cumbersome to get consents from customers for any types of data transfer. And you really don't want to have to go back to customers for that. So the question is, how do you use that data? And one innovative thing that we're actually employing on deals, this is both spin out transactions and collateralization deals, is a data services relationship where one party retains the data and then it conducts data analytics and aggregates the data, de-identifies it, gleans insights from it. And then it performs data analytics services on behalf of the other company. So they might say, oh, we believe, this program might be successful based on the analysis we've done with the data. Therefore, the other data does not actually know the specific data elements like email addresses or phone numbers, yet it has the information necessary to operate its business. And these are often performed, on a services basis relationship between the parties. And it's one way that you can be innovative in transforming your business to get around some of these issues where you might say, oh, I can't transfer the data, but there's still a way that both businesses can benefit in that situation. So then I'll turn it on to Emily for the last hypo.
Great, thanks, Georgina. So this last hypo is about open source software where we're seeing an increased focus on diligence in the transaction context, where strategic acquirers have a renewed interest in ensuring that target companies are in good compliance with open source licenses and have been developing adequate policies and engaging in just good hygiene with respect to their open source. So a true story, but the names have been changed. Coders Inc. was founded by 2 software developers in 2008, expanded to hundreds of employees, developing tons of software programs and apps. In 2020, Coders is approached by Soft Micro with an offer to buy the company. In diligence, Soft Micro describes how it will conduct its code scan and will require coders to remediate any issues that are revealed through the scan. The code scan takes weeks. It's a huge burden and obligation, and Coders has to dedicate significant resources to tracing down all of its open source components in its platforms. The scan is identifying many components that are subject to viral licenses. Ultimately, Coders isn't able to remediate the issues and the deal falls apart. So some tips that we always advise companies who are considering entering into a transaction. You need to consider your open source strategy early on and have a plan with what kinds of licenses you're going to be incorporating into your proprietary software. It is always a good idea to establish open source software policies and procedures, and there should be checks on how developers are using and incorporating open source in the development of their software. You will want to conduct routine audits and remediate open source issues as they arise. And ensuring understanding and compliance with your underlying licenses. Oftentimes we're seeing the larger acquirers come in and tell smaller companies that they're going to integrate all of their source code into the acquirers' products. So they really do need clean hygiene, and we want to make sure that, rather than fixing it on the back end, you have everything ready to go in the event that you do a potential sale. Regina, can you take us through the wrap up?
Yeah, so I don't think there's any final points here, but just to hammer it, the first step in any inquiry as part of the IP diligence process is to identify the issue. But again, that's not nearly enough. There's usually the next step of the analysis of what do you do about this? And as you've seen through the 5 case studies, it's a complicated question where there's further sub issues as you delve in. And it's important to talk about all of these issues very early on in the process, because there's going to be a process of transforming your business to adjust to these types of risks. So if you're going to take away one thing, it is identify things early and speak with your legal counsel as early as possible in terms of how do you manage the risk going forward. So I think with that, we're happy to address any questions or comments from the audience.
Carrie Jordan asked the question, can you speak to the intent to use trademark applications issue again?
Sure, great, thanks. So this is a US specific issue. And in the US, you can apply for trademarks on the basis of use in commerce or on the basis of an intent to use. And so in order to actually get a US trademark registration, you have to eventually demonstrate use of that trademark, which is very different from most other countries in the world. And the intent to use trademark application is a way that an applicant can reserve its place in line and claim priority back to that filing date once they actually do put that trademark into use. Because as you know, once a trademark is chosen, or a brand is chosen, it can take some time to actually commercialize it. But the US trademark laws have a prohibition on assigning intent to use trademark applications. And the reason is to discourage the trading of trademark applications as a business, right? Or squatting on them. So without this restriction, somebody could just think of some great trademarks, apply to register them, and then try to transfer them for a high price to people who might actually want to use them. And so to discourage that kind of behavior, an intent to use trademark application cannot be assigned until the trademark has actually been put into use. And there's one exception to that, which is you can assign it to the successor to a business that is ongoing and existing. And so in a typical M&A situation where there's a buyer of all the assets of a business or the stock of a business, well, it wouldn't matter for a stock purchase, but all of the assets of a business, that an intent to use trademark application that had been filed by that business can be assigned. That's the intent of that exception, because the whole business is being transferred to a new owner. But in a lot of situations, when companies undergo internal restructuring for tax or other reasons, they may be moving a trademark portfolio to an affiliated entity, but they're not actually moving the business to that entity. They're specifically just moving the trademarks with the intent of assigning or licensing those trademarks back. And in that scenario, you actually can't assign the intent to use trademark application until the trademark has been put into use and there what's called a statement of use or an amendment to alleged use. And once that has happened, then the restriction on transferring it goes away. So in that situation, normally you have to license that trademark to the party that is ultimately going to receive ownership until that use is filed, and then you can assign it. Hopefully that answers the question, but I'm happy to talk about it further if anyone has follow-ups.
We have another question in the Q&A, and this question is, from a practical perspective, how do you do the open source scan?
Sure, I can take this one. So there's two real ways that we see folks doing open source scans, either internally or through hiring third-party providers who can run comprehensive code scans and just go line by line through your code to evaluate any what open source components are included, what the applicable licenses are, what vulnerabilities you have, and what where you might have non-compliance. So before you get to a third-party provider place, we just see companies running their own internal records to confirm that they have all of their open source components and they understand what the applicable licenses are, and they're keeping good records and track of those for, if they needed to produce a full list of all of their code.
Hi, I had a quick follow-up question on that. Is there, if you were to run that internally, is there like a database that you know of on GitHub or somewhere where you would be able to identify the open source that's available and then use that to compare with your code? Like how does that exactly work?
Yeah, exactly. So we would normally recommend you look on GitHub, find the applicable component. I mean, best practice would be to have your developers run every component of open source that they're planning to integrate by someone before they actually integrate it into the code. So you can review the applicable license, and then it's just a simple search on GitHub to ensure that, if something is licensed under a viral license, that you're not going to be facing any issues down the road with non-compliance or requirements that you distribute your code, your proprietary code.
Terrific. Well, I'd like to thank everybody for joining us today, and in particular, Erica, Georgina, and Emily from Ropes and Gray.
Thanks, everyone.